morning, everyone. It's Friday morning, and welcome to breakfast at Brodies. Today we're going to be discussing what life is like as working within the retail and leisure property team of Brodies, and also we'll be looking as well at what life is like working within the hotels team. And a number of our lawyers actually cross over between both teams, and we'll be touching upon that later today as well. My name is Colin Morrison. I'm a real estate partner in the commercial property team. I also head up the retail and leisure groups and the hotel groups. We are really pretty busy at the moment and really quite excited about the future. And I thought today we might discuss what the typical workload is for both teams, and the kind of transactions that we're involved in. So I think beginning first with retail and leisure, I think it's probably quite useful to actually define what we mean by retail and leisure. And for some reason, the industry and indeed ourselves at Brodies, we really look on retail and leisure property being the tenant occupiers, the occupiers and users of retail and leisure property, as distinct from the landlords of retail schemes or landlords of retail or leisure property developments. The wider industry recognises that as well, that most of the legal directories, when they talk about retail or leisure, they actually talk about the occupiers too. So we have probably the largest retail and leisure property team in Scotland, and we act for more retail and leisure clients than probably anybody else. We're at the top of the directory rankings. In fact, the size of our team is such that we have been sort of classified in our own band within the largest legal directories for a number of years now. Regularly, we would act for approximately 120 retail organisations every single year, and approximately 50 leisure occupiers every year. These retail occupiers are amongst the largest names in the retail world. Lots of them are household names. Zoe, have you got the list there of some of the names that we have? As you'll see, many of them are household names, and we act for them generally in respect of their whole portfolios they have in Scotland. Scotland's obviously a small country, but some of them can have portfolios of as many as 100 shops in Scotland. Some might only have one or two, but they in aggregate represent quite an impressive client list. To put that in scale as well, if you think about the new Edinburgh St James Shopping Centre, we have acted for 28 of the occupants in the new shopping centre. That's roughly 1 in 3 of all deals in that shopping centre. If you think of some of the major retail thoroughfares in Scotland, if you think about Princes Street, Buchanan Street, George Street in Edinburgh, it's not infrequent for us to have acted for roughly half of the occupiers in particular blocks on these streets, and in other shopping centres we've acted for over 1 in 3 of all the tenant occupiers in these centres. So when we act for these retail organisations, we aspire to do all their legal work in Scotland, but the inevitability is that most of these organisations are based down in London. Quite often they're headquartered actually abroad, and therefore they have their own in-house legal teams, and they know what they're doing. They maybe have their own corporate teams, their own employment teams, and therefore really they come to us more or less for just areas where they need specialist Scottish legal advice. Generally that is litigation and real estate. From the real estate perspective, we're generally involved in all the real estate work when they come to the Scottish market. That usually begins with obviously a lease acquisition or a property acquisition. And from that, we will then be involved in their estate management work, any rent reviews, any refurbishments they have for those stores or restaurants or whatever the property is. And ultimately, potentially, their disposals of those properties. I mentioned there that the bulk of the transactions actually revolve around a lease. And leases are effectively the commercial lifeblood of the commercial property industry in all across the UK, and particularly so in respect to the retail and leisure sectors. The reason why retailers are particularly drawn to leases, there's a number of key reasons, but the key one is that they do not want to deploy their capital into bricks and mortar. They are fundamentally about selling things. They're about selling clothes, or in the restaurant sector or the wider world, it's about trying to sell hamburgers or whatever their core purpose is. It's not about tying up capital in bricks and mortar. Therefore, leases allow them to grow and expand swiftly to the locations they want to do, relatively cost effectively. But there was a price they have to pay for that, and we'll come to that when we're examining what commercial leases involve. The other benefits are that leases offer them slightly more flexibility than they would have in respect of acquisitions of bricks and mortar. If we think about a retailer such as Next, when Next first arrived in Princes Street in Edinburgh, they had a tiny shop. Then they graduated to the one where Starbucks is at the west end of Princes Street, which is currently on the first floor. And then they expanded from there into a slightly bigger shop. And now they're trading from a department store. They are, their graduation over 20 years has been quite remarkable, and that's roughly the lifespan of some leases. And they are able to sort of, through lease disposals, able to sort of upgrade and change and assign and sublet and maneuver, which they might have been unable to do if they were tied up in ownership or bricks and mortar on Princes Street. So the commercial property lease that we deal with is actually a relatively new creation. It really came into form. There'd always been leases, but the commercial property lease that we kind of recognise really emerged in the sort of late 1970s, early 1980s, and it became it became a sort of recognisable instrument, which I think is worth actually taking another step back and actually thinking about that and why they exist. The reason why landlords get involved in commercial property is fundamentally about them finding commercial property or real estate generally a more attractive asset class, effectively, for their money than certain alternatives. So they decide to put their money into real estate as opposed to keeping it in their bank account or buying government bonds or some other form of asset class, because they believe they will get better returns for their money. So you hear a lot in commercial property about yield returns, and very simply, that would be, say a landlord comes along and wants to buy a shop. Say the acquisition costs are, the purchase price for that shop, say 900,000. But then when you add in your LBTT, you add in your solicitor's costs, your surveyor's costs, you may well have a £1 million purchase commitment from the landlord. The landlord then manages to lease that property to a tenant, and that tenant is willing to pay a rent of £50,000 a year. So he's generating £50,000 based upon his £1 million commitment. So effectively, he's got a 5% return. That's what we're referring to, 5% yield on his investment. Now that's quite attractive if you actually set that aside to alongside, say, bank interest, which may be at 2%, government bond yields, which may be 2.5%, 3%, and other forms of investment. There's also the potential for capital growth too. Therefore, all very good for the landlords, and suddenly retail property sounds fantastic. But the key thing at that point is really for the landlord to ensure that that money, that rent, that return is going to flow throughout the lifespan of his investment plan. And to do that, he needs to ensure that that 5% is preserved, and he's not having to constantly compromise that or dip into that to meet other liabilities. Therefore, the modern commercial lease basically is structured in such a way that the tenant effectively pays for virtually every aspect of the owner, basically pays for every aspect of the occupation of that building, and basically absolves the landlord from the some normal costs of ownership. So, for example, if there's a defect in the building, if there's a defect in the roof, if there's structural issues in the building, the tenant is found responsible for that defect and will have to pay for it. Even if that defect only emerges in the last few months of the term of the lease, the tenant is technically liable for it. The building will need insured. The tenant must pay for that insurance. But the benefit of any insurance will go to the landlord. If for example, new legislation comes in regarding environmental sustainability, and improvements are required to the building. If, for example, the building is not DDA compliant, or there's asbestos found in the building, again, it's the tenant every single time that will require to address those issues and pay for them themselves, even though there will be a day coming not too far away where they actually have to hand back the property. So the landlord's agenda is to ensure, just like you would do as if it was like another form of investment, that they have an unbroken income stream coming through. Now, our job as retail and leisure lawyers is to basically manage that process and try and limit the controls of what the landlord is doing there. There's a general acceptance that the landlord does have a legitimate FRI agenda, and will have a legitimate agenda to protect his investment, but we also want to control that situation so that the tenant is not facing unduly onerous bills and or liabilities that may far outstrip what they would normally expect to pay for property costs. And that is the skill of really what we're trying to do here, managing those costs, managing those liabilities. And that may take the form of when we're taking on that full repairing responsibility, making sure the condition of the building is in the shape that we anticipate or require it to be in before we go in. We want to basically survey the building and make sure that any defects in the building are drawn out and identified before we take entry. And if we see that there's a potential roof repair coming, we would maybe want to expressly exclude that from the liability of the tenant going forward. We also want to control the ability of the landlord to grow the rent. We want to control the stranglehold that the landlord may have in respect of alterations and other things. So effectively, we've got to balance the interests of the tenant with the interests of the landlord and their investment agenda. The leases are, remember, fundamentally commercial contracts, and in Scotland, they are very literal commercial contracts. In England, the retail world is underpinned by statute, where they have the Landlord and Tenant Act, which provides a foundation effectively to the relationship between landlord and tenant. But in Scotland, we don't have that protection. If the landlord is unduly holds an unduly inequitable position in the lease scenario, and we've seen that several times, particularly in relation to dilapidations, particularly in relation to buildings where unforeseen or inherent repairs emerge during the term of the actual lease. There is no protection. It's the tenant is on his own in this one. Whereas in England, there would be certain protections that would be able to protect the actual tenant. So we've got to be very careful in that battle. But what we try and do here at Brodies is try and educate our lawyers into knowing that the arguments both for the landlord and for the tenant. And so they actually end up having a fairly balanced view of things. If you're aware of the other side's agenda and you're aware of the challenges that they're facing, then you will be able to sort of more swiftly move towards a compromise and be able to steer to acceptable commercial outcomes. So the next slide was just simply just to indicate some of the leisure occupiers we act for as well. They include cinemas, restaurants, pub groups, and you'll see that our involvement with them is very similar to our involvement with the classic retail occupier tenant, albeit that leisure occupiers often have more requirements as far as services are concerned. They quite often need to have extract flues and systems with regard to waste, which are over and above that, which you normally encounter with retail occupants. And they also operate through a different use class as well. So this is something we'll come to later on as we're looking at the repurposing of retail property. So once you understand the relationship between the landlord and the tenant, you can then really approach the lease discussions and lease negotiations with that balanced point of view. We know that if we push the landlord too hard, then the deal is unacceptable for them. And not only the landlord themselves, but also the funders that stand behind the landlord. The landlord in certain instances may be willing to strike a deal with a tenant, but their funder may decide that what we're pushing for is unacceptable. And sometimes we have a bit of tension there. Equally, the landlords, the skill in the negotiation with them is just to make them fully aware of the operational needs and requirements of tenants. Tenants are not in the business. Retail and leisure operating tenants are not in the business of property. It's an incidental to their core purpose. They are fundamentally about selling things, and they just so happen to have a property portfolio. I remember going down to Asda in Leeds about 20 years ago, and I sat in their property department for an afternoon. And we're there discussing some key property deals, and the property guys were at that point doing incredible deals. They were doing huge sale and leaseback projects worth several £1 million, and they were creating real value for the Asda business. But they're all sitting there in this room, and they were facing this glass wall, and behind that glass wall were a number of chefs. And it's the guys involved in the department that created Asda brand recipes, and these chefs were standing there with their big white hats on and their overalls, at their kitchen tables, and they were facing out directly opposite the property guys, and it was like a face-off between the two departments all day. And I commented on this during the course of the day, and somebody pointed out to me, well, these guys and these chefs and these guys involved in that department have always got to appreciate that whatever they're doing, they've got to appreciate that the guys who are in the property team are there doing incredible deals, creating incredible value for our company. But the property guys at Asda must never ever forget, Asda's there to sell beans, and that's the core, and that's what all our retail clients are there for. They're not there for the sake of being in nice shopping centres. They're there because they have operational requirements. They need to interface with their clients, and property is just an add-on for them. And if they can't operate in the way that they want to operate, if they can't operate a restaurant in the way that they need to operate, then they'll move on to another location. And landlords are beginning, I think, to recognise that. And we'll speak about that in the context of the change shortly. So the typical lease that we would encounter would be, well, it depends in the context of the actual transaction that you're involved with. So you may well have a new build property, and in that scenario, you would have an agreement for lease. And that agreement for lease document would basically regulate really the circumstances leading up until the grant of the lease itself. And those circumstances would regulate the timing of the commencement of the lease, and all the events that need to take place up to the point of the lease commencing. And that may well be, as I've touched upon earlier, making sure that the property is in the condition that we want it to be in order that we might begin to accept the liability that comes with a commercial property lease. So that may well be that the landlord must carry out works to repair damages. In the context of a new build, it's that the landlord completes the building and completes it to our satisfaction. The agreement for lease may also regulate any particular requirements we have for planning or change of use. For example, leisure operators frequently occupy premises that were previously occupied by retail tenants. Retail tenants occupy and operate under Class 1 in the use classes order, whereas the restaurants and other leisure operators generally operate under Class 3. So we would need to get planning consent for that change of use before we would allow the lease to commence. Also, incentives often pass between landlords and tenants, most frequently from landlords to tenants. And usually that capital contribution is utilised for the cost of fitting out the premises, which can run into the millions. Therefore, we regulate as well the passing of that money and how that is spent and the tax efficiency around that. So the agreement for lease document covers a lot of different areas, and that probably takes as much time, if not more, in negotiation than the actual lease itself. Then we have the actual of the lease, which really governs the liabilities of the parties from the commencement. The majority of leases these days run for about 10 to 15 years, and if you read through them, they do still seem fairly one-sided in favour of the landlord, but there is generally a journey to be more and more collaborative. About, if you were to look at if you were to encounter sort of standard commercial property lease about 15 years ago, when the world was rosy, pre-financial crash, landlords were doing very well in their yield returns, and before online retailing really caught on, you would probably see some pretty standard looking lease documents whereby the landlords would dictate the terms and the tenant would be happy to get them. It was all about the location, and if the landlord held a good location, the tenant would effectively, agree to whatever in order just to get within that location. And then once they're in there, they would face upwards only rent reviews, and they could find that over the lifespan of their lease, if it ran for 15 to 20 years, it could well, almost double their property costs over the lifespan of the lease. Nowadays, the pendulum has swung more towards the tenant, and not to the complete detriment of the landlord, but there's more of a recognition that if there is to be a future of the high street, if there's to be a future in shopping centres, then the relationship between landlord and tenant needs to be more balanced. And you do generally see more collaboration between landlords and tenants. The language that landlords talk about, what the landlords use when referring to tenants has changed now as well. They talk about them as partners, they talk about the relationship with them, they talk about them as clients. The landlords actually approach the tenants regularly to sit down with them and ask them, what more can we do for you to keep you happy in the shopping centre? What more can we do to enhance your retail environment or your leisure environment? The mood music has changed, and the actual format of leases changed as well. They've become more contractual. Before, a commercial property lease would be, as I was saying, a fairly standard document, but now you do have far more bespoke provisions in there. If you take an operator such as, say Zara, they operate giant stores, but they now generally operate through with large elements of their rental liability being linked to actual turnover performance. So the landlord can no longer guarantee their 5% yield. They will only get a return if they create an environment that is conducive to generating a high turnover for Zara. Zara then get the upside of that, but so does the landlord. The landlord share a percentage of the overall turnover that the landlord gets. But then this creates further questions, because then we start looking at what constitutes turnover. Do online sales constitute turnover? Do click and collect sales constitute turnover? Or even if you're in the store with your iPad or in the store with a mobile device and you buy something in the store, would that constitute turnover? There are lots of different questions there. And it's frequently, the turnover provisions of a lease can now span out to 4 or 5 pages as you try to articulate and define exactly what constitutes turnover and where the landlord can generate a return from the activities of the tenant within the building. Retailers are also looking for more autonomy, more flexibility within the buildings themselves. The retailers know what they're doing. They know how to optimize sales, and as long as they observe certain quality thresholds, the landlords are more likely now to allow them to have freedom to actually do what they want within the store in order to optimize the turnover returns. You can also see in leases now as well the advent of provisions which are a direct result of the recent pandemic and COVID. Pre 2020, if a lease was basically, there was enforced closure of a retail premises, through the keep open provisions in the lease, the tenant would technically still be obliged to keep open, even though the trading circumstances dictated that they could not stay open. And also there was no forgiveness if they were effectively mandated by law or really through the wider situation to actually close the store. And so a lot of tenants found themselves actually facing ongoing rental liabilities throughout the pandemic. So the industry is beginning now to react to that, and you're seeing more and more circumstances whereby we have pandemic forgiveness clauses, and effectively the landlords and tenants are working together in these circumstances. Well, previously they may well have come to some kind of arrangement during the COVID crisis, but that was a voluntary arrangement. Now formulas are being inserted into leases to cover for periods of enforced closure such as that. We're also seeing, more and more in relation to, for example, the leisure operators that we're dealing with, more and more provisions coming in regarding the realities of some of the off-site sales that they have. So we now have provisions within the restaurant leases that we're doing covering sales generated through Deliveroo or Uber Eats, and these kind of delivery operators who work in tandem with a lot of restaurant operators. And again, we're back to the discussions around, well, is that genuine turnover for the units, or if you have to pay commission to these operators, should that be deductible from the turnover? And that's a new battleground with the landlords. But it's really interesting. It's all become a lot more contractual. Every lease is becoming different. Every lease has got its own nuance, and it's really interesting. And previously, for maybe 20 years, the commercial property lease hadn't evolved, but in the last 10 years or so, and particularly in the last 3 or 4 years, we have really seen a fast evolution of the nature of the commercial property lease as people are reacting to the challenges of the pandemic, challenges of Brexit. Remember, retailers and leisure operators are really suffering when it comes to trying to attract staff, and their staffing costs are becoming a lot higher, and it's led them to a number of very tough decisions when it comes to property locations, and of course in relation to online retailing and all the challenges the new world presents. And one of those the ways that they've reacted to that is the introduction of lots of tech within their stores. And again, we are increasingly seeing provisions within the leases for the more innovative retailers and leisure operators, providing specifically for tech and the introduction of tech in the stores. Most of the operators are looking to try and have carte blanche when it comes to their introduction of tech and fibre into their units. The landlords are trying to retain some control, and that's a new battleground again in these commercial leases. So that's a brief discussion there on the kind of nature of the documentation that we're looking at. We also will have license for works agreements governing any refits that they may have. The landlords might also want to have guarantees, bank guarantees, rent deposit documents. But in aggregate, we're looking at a suite of documents around every lease acquisition, which can extend, if you build in all the specifications and construction documents, to quite a substantial bit of paperwork. Most of the deals we were involved in at Edinburgh St James ended up with contracts which probably are equivalent to a doorstep. And they actually involved, allowed us to involve other parts of the office as well in our negotiations. We regularly brought in experts from our planning teams, from our construction teams, from licensing. In the advert, for example, of the Everyman Cinema deal, licensing were involved in obtaining not only the alcohol premises license, they were also involved in getting the entertainment license for the cinema, and outside seating. That it's really interesting to watch all these different teams from across the firm all interact together for the purpose of one project. As I was saying, for the sort of typical transactions we've been involved in have evolved over the course of the last few years. Edinburgh St James, that development, if you actually step back and have a think about it, actually came out the ground during probably the most difficult period I think the retail industry has ever actually experienced. The project had its green light just before Brexit, and then online retailing really kicked off. And then just at the peak time, just in the last 6 months before delivery, the pandemic struck. And I must say that Nuveen have done very well in actually sticking to their guns and actually delivering a world-class scheme in the centre of Edinburgh. And that's transformed the centre of Edinburgh. As I say, we've been involved in 28 deals in that centre. And one of the things that we've noticed as well, that the occupiers that gone into that centre are not there simply to sell things. There are a lot of experiential occupiers going in there. This shopping centre, and you'll see this more and more in our high streets, the shops that are being taken in many cases are really there as platforms and outposts really for engagement with customers. So clients such as Peloton, Miela, they're there to allow these operators to actually interface and meet with their customers as much as actually trying to sell volume, as you would traditionally do in a retail context. A large part, though, of our practice in the last few years has, however, been involvement in insolvency aspects of the retail industry. As you will probably read about in newspapers, has been all over TV, many great names have disappeared from the high street, or many have had very sort of difficult times. In the last few years, we've been involved in insolvency events and restructuring for retail organisations such as BHS, Clark's, New Look, Outdoor Concepts, Jack Wills, Exercise for Less, Phones for You, Casual Dining Group, Forever 21, Restaurant Group, Scotsman Hotel. And these tend to be significant projects that really take out large parts of our retail team whenever they go live. Effectively, these projects involve agreement between these retail organizations and their landlords. And usually they arise when the tenant company, the retailer or the leisure operator, looks down the pipeline and realizes they cannot meet their liabilities, or their business model is unsustainable as they are carrying on. And as we came out of as I was saying, 15 years ago, the property industry was very robust with lots of upward-only rent reviews, and that left a lot of retailers and leisure operators facing very, very high property costs in relation to their portfolios. And it was just unsustainable in a modern world where these same operators are dealing with the challenges of Brexit, dealing with the challenges of online retailing, and in recent times dealing with the pandemic as well. So we have worked with a lot of these organizations, often in conjunction with insolvency specialists, in restructuring their portfolios. And probably the most frequent one, the frequent model will be voluntary arrangements with landlords. And effectively, the retailer will approach their portfolio of landlords and explain to them, we need you to support a restructuring of our rents across our portfolio. Otherwise, we'll go into enter into administration. If we enter into administration, you will lose your tenant or potentially lose your tenant. And the landlord then is facing the scenario of not only a reduction in their, say, 5% yield from that tenant, but potentially it reducing to zero. And in the wider landscape, it is really it's quite difficult to see where replacement occupiers are going to come from. So that's been a big part of our portfolio of instructions in the last few years. And the sort of third big tranche of work we've been involved in has been what we call repurposing, and that's some retail and leisure repurposing that we have seen across our towns and city centres. As a lot of let's take for example Edinburgh city centre. As mentioned there, a lot of retailers have suffered, and they've entered into administrative arrangements, and some of them have had to close shops and they won't be returning again. But many other occupiers have actually drifted into the Edinburgh St James shopping centre. Others have relocated to be near the Edinburgh St James shopping centre, which has left a lot of gaps, a lot of voids around the town centre. The retail agents then look around and actually can't find occupiers to replace those retailers or leisure operators who have relocated. And therefore, the property owners, the landlords, have been looking at alternatives for those spaces. And quite often that involves actually seeking a change of use. And as we've seen on Princess Street, we're looking now at lots of locations which were traditionally retail, converting into hotels or converting into restaurants or other formats. And we see that, again, as lawyers, as quite exciting. Well, on one hand, it's quite sad to see things, landmark operators or buildings changing to that effect. If you actually go back through the annals of time, you will actually see that Princess Street has always changed. It's always been dynamic. Some retail has always evolved. It's always been trends, and we're really involved in a lot of those different aspects. So that leads me to think, why would you want to be a retail lawyer? One of the things that I like about being a retail lawyer or a leisure operator, it's just the sheer variety of transactions that you have. You're dealing with a lot of different different scenarios every day. And I was just saying, as I mentioned earlier, it is far more contractual than it used to be. You really do have to sort of get involved in bespoke drafting in every single deal going forward. In Edinburgh St James, we're doing specific drafting around stock delivery from China at one point, and how that affected the capital contributions that this particular occupant was going to receive. Really interesting work, and it basically allows you to deploy a lot of skills when actually operating here. It's definitely not formulaic transactional work. It's also very tangible. It's something really appealing, and be able to walk down the street and point to buildings that you've been involved in. To be honest, you get invited as well to a lot of opening parties that can be quite appealing. Next week, we're looking forward to going to the Everyman cinema opening in Edinburgh St James, which will be great fun. It's also nice going into restaurants that you've been involved in and being looked after by the general manager or the owner of that restaurant. So yeah, it has got a more tangible output than many aspects of commercial property. It's also you also just meet some incredible people. I mean, my wife was just listening to me the other day on the telephone, and in the morning I'd been speaking to Germans and to Spanish clients. Over lunchtime, I was speaking to some Danish clients, and in the afternoon, I ended up speaking to American and Canadian clients. And I hadn't really appreciated that at the time. They were just my clients. They were just guys that I dealt with every single day. But you do get to enjoy dealing with those individuals from those different countries, learning about their cultures. And to be honest, there is a bit of travel involved in that as well. I've been out to most of those countries with the work hat on, and have seen the operations of these various organisations. Really enjoyed meeting them. Really enjoyed learning about what really makes them great, and that has allowed us to come back to our desks and actually implement and reflect some of those issues in the documentation that we've been drafting. I've just had a flag that we've only got a few moments left. Just what I was going to say, hotels. We are also very much involved in the hotel sector. We do. It is not dissimilar to the approach that we have in respect of retail and leisure occupation. Probably the main difference being is that while the commercial lease would be the lifeblood of the retail and leisure world, in the hotel world, we would tend to split between commercial leases it tends to be smaller operators, or a document known as the hotel management agreement, which tends to be utilized by the bigger brands. And while the commercial lease allows these bigger brands to avoid deploying capital in relation to their growth and their operations, the hotel management agreement takes that to a further extent, where effectively the brands that we recognise as Holiday Inns, the IHGs, the Starwoods, etc., the Marriotts, these guys really don't deploy any capital when it comes to their operations. When you see them involved in a building, what they're involved with through their hotel management agreement is the provision of their reservation services, their ability to operate the hotel, the ability to provide their stamp on a building and provide service levels that you expect from that brand around the world. The owner retains far more involvement in the building, and the management of the building, and the hotel management. They vary from building to building and operator to operator, but fundamentally, it's about the division of responsibilities between the brand that operates the hotel and the owner. They're very interesting documents, but we tend to act more for the owners when it comes to hotel management agreements. And that is simply because most of the brands, most of the hotel operators actually have their own in-house legal teams, which basically look after those documents themselves. Nobody knows the requirements of a client better than the client itself. And if they employ their own in-house legal counsel, then obviously they are they have that direct route. But the owners of commercial property don't have that specialist knowledge, and that's where we step in and we help them with negotiations against hotel brands. And interestingly, the recognised sort of jurisdiction for hotel management agreements across the world really is English law. So our team here are all qualified in English law. And that means that they actually regularly get involved in projects in the Middle East and in Africa, in the United States and the Caribbean around hotel management agreements, acting for owners. They do not really get involved in they won't get involved in the real estate aspects of those particular projects, but from a contractual level, they'll engage with in-house management, the in-house legal teams of these big brands when dealing with them on those projects. I think we've run out of time, so I'm just going to wrap up there. But my details will come up. Yeah, there they are on screen just now. So apologies for running out of time there and cutting short the hotel presentation. But if anyone is interested in discussing any aspects of what I spoke about today, or to continue the discussion around hotels, please do reach out and get in touch with me. But otherwise, I will leave you there and let you enjoy the rest of your sunny Friday. Thank you. Bye-bye.